right, go ahead and movement. Go ahead and announce the case name and cause number.
All right, the case is XPRS Capital LLC versus Korean Meat and Supply LLC, Nina Chang and Michael Dean Brown, both individually. The cause number is DC-20-03704. Defendants are moving for summary judgment as to plaintiff's claim based on their affirmative defense of usury. The note charges an annual interest rate of 39%, which is way over the legal limit, and entitles defendants to penalties under multiple provisions of the Texas Finance Code. When you apply those penalties towards the total amount of plaintiff's claim, the amount of penalties exceed the amount of their claim, and so defendants are seeking a judgment against plaintiffs in the amount of the excess, which is $49,617.08.
Is that it?
Sorry, Ms. Quirk, can you give me that amount again?
Sorry, it is $49,617.08.
Thank you.
And is that it?
Essentially, I mean, it's a very simple defense. The math all checks out. I think that most of the arguments going to occur based upon their alleged defenses to RMSJ, and I don't want to characterize their legal argument for them. So.
Okay, Mr. Foley.
Thank you, Your Honor. First, I would like to point out that she's asking for affirmative relief in her motion. She's asking for an award of a $49,000 judgment in her favor. That is in the character of a counterclaim. I'm sure you'll see in the court file there is no counterclaim pending, so she would not be entitled to an award regardless of what the rest of the facts are. So I would also like to point out that the damages that she's seeking fall under Section 305. She references that in writing in her motion. What she fails to point out to the court is Section 305 only applies in contracts for personal, family, or household use. This loan is not for personal, family, or household use. Therefore, Section 305 and the penalties thereunder do not apply. In fact, if she were able to prove usury, which I'm not conceding she does, under Texas law, she'd only be able to wipe out the interest that is claimed, not receive an affirmative award and not wipe out the principal unless this is personal, family, or household use. You can see by just the caption of the case, XPRS Capital LLC versus Korean Meat and Supply LLC. Those are two different companies. They're businesses, they're properly formed. The loan was not for personal, family, or household use. It was for business use. As to the guarantors, even though they are individual, it's not for their personal use, it's still a business use. And technically, usury cannot be a defense for a personal guarantor. It's primarily for the principal obligor, in this case, the LLC. So again, regardless of whether she could prove usury or not, the damages statute that she's applying does not apply to this case. I do also want to point out that the contract itself in bold letters says that California law applies. Under California law, XPRS Capital is not controlled even by California usury laws. It's specifically exempted as a professional lender. And finally, the savings clause, there's a savings clause in the note that says in no event will this contract be interpreted to grant interest in a usurious rate. So again, the best she could do is wipe out the usurious interest under the terms of the note, even under California law. Therefore, I believe her motion for summary judgment should be denied.
Response?
I think that our reply brief addresses the savings clause issue pretty clearly. The savings clause is not effective when on the face of the note, the interest rate is usurious, which is the case here. And it's very well established that that's the case. You cannot escape the penalties for usury by tacking on a savings clause at the end and just say, just kidding. As far as the California law being waived, our California law, we would say, is waived because they have proceeded in Texas, in a Texas forum, and all of their pleadings reference Texas law. They have not properly requested that California law be applied. They filed a late request to apply California law. They've not requested a hearing on this matter. And they've only asserted that at the 11th hour just before trial. So based on their use of Texas law for the entire year and 3 or 4 months that this case has been pending, we would say that they've waived that choice of law provision because it is a waivable contract provision. As far as the argument on the finance code, I'm looking at chapter 305 right now, and I do not see a limitation. So if there's a code section that you have, Mr. Foley, that you're citing for your claim that this section doesn't apply, I would like to have that code provision.
What section are you relying on, sir, Mr. Foley?
Let me find that exact section. And while I'm looking for that, I would like to object to the response brief because we were not provided one. But let me find the exact section here. I just looked at it moments ago, so it just may take me a second to find it.
Your Honor, my reply brief was filed timely on July 21st through the e-filing system. And I do have confirmation that it was served on Ian McCarthy, who is the counsel of record in this case. So I don't know why he believes that it was not served, but
Okay.
Your Honor, I know that I saw that. If I could have that statute sent to the coordinator for your review and counsel within a half hour, I'd hate to have you sit here while I'm poking through.
Go ahead and poke through. What section are you relying on, Ms. Quirk, again?
the penalties are under chapter 305, section 001 and 002. While Mr. Foley was responding earlier, I was scanning through that chapter 305 and I do not see that limitation. I wasn't prepared for that argument because it was not raised in their response. So I have not looked into this claim that this provision is inapplicable.
Okay.
So section 305.002, those penalties say that they're unavailable to only to a contract for transactional for personal, family, or household use. But there's no such limitation on the penalties for section 305.001.
Your Honor, 305.002 is the one that I was referring to, and it refers to the entire act, all of 305. When you look at 305.002, it isn't limited to just .002. It encompasses the entire 305 of the code.
I would disagree with that assessment. That subsection specifically says this section applies. So I would not say that that's indicative of the entire chapter.
Okay. Let me kind of look at this real quick. Yeah, it would seem like the section you're relying on is just for 305.002. So 3.305.001 is liability for usurious interest. And what it does say for this one also, it says on 305.001A, the creditor who contracts for, charges, or receives interest that is greater than the amount authorized by this subtitle in connection with the transaction for business, family, or household use is liable to the obligor for. So I think both 305.001 and 002 are limited to personal, family, or household. Am I missing something here? Ma'am?
No, Your Honor, I am looking at that right now.
You see what I'm talking about?
Yes, I do
305.
see that.
But then you have, okay. And then you have 305.003, which is liability for usurious legal interest. I'm not exactly sure how that differs. It says a creditor who charges or receives legal interest that is greater than the amount authorized by this subtitle is liable to the obligor for an amount equal to 3 times the amount or $2,000, whichever is less. This section only applies to transactions subject to this subtitle, which would seem to be just for those types of for family. I don't know, is there any case law that interprets any of this?
I have not looked at 305.003, but it would appear that the remedy is essentially the same. I would argue that they're computing the same. It's 3 times the amount computed by subtracting the amount of legal interest, which is the exact same provision in 305.001. So I think that this is a carve out for other loan transactions. Otherwise, this provision would be superfluous, and it would just be limiting the remedy that was just provided in 305.001.
Okay, so I'm looking at causes of action for O'Connor's. Let's see.
And chapter 305.004 seems to mirror 305.003, or sorry, 002, which provides for the increased penalties when the rate is more than twice the legal amount.
Let's see. All right, so if you look at chapter 31 of causes of action, O'Connor's, it talks about usury. And it says a statutory claim for usury is brought under Texas Finance Code Title 4, which includes 2 relevant subtitles, A and B. Subtitle A, interest, contains Texas Finance Code chapters 301 through 339. Let's see. Because each subtitle provides different rules for a user claim, it's important to know which subtitle governs a particular transaction. So what type of loan was this exactly?
It was a commercial loan used for the business operations of Korean Meat and Supply LLC, which is an entity that's essentially gone completely defunct. They're no longer operating.
Is it for more than 250,000 or less than 250,000?
Less than 250,000, Your Honor.
So apparently, according to this, I just a quick look at this, that would be governed by 306.002. All right. Well, none of this was briefed, though, right? None of this.
No,
Texas Finance Code.
no, Your Honor.
Mr. Powley, why didn't you brief this?
Your Honor, I honestly don't know why we did not brief it. I just realized that there was a discrepancy in the relief she was requesting under the, she's requesting under the improper statute. I realized it this morning, and so I raised the issue in argument. Even if I didn't raise it, I believe Your Honor has an obligation to look at the statute under which she's requesting her relief, and as we're discussing now, find that 305 is inappropriate.
All right, what I'm going to have you guys do is just provide me a supplemental brief on this topic. I'd like it by tomorrow. It just needs to be 2 pages or less just on this topic. So if there's any cases that I read to you, if you guys have O'Connor's causes of action, it has an extensive discussion about this. But give me the supplemental briefing by tomorrow. Does that work for you guys?
Yes, Your Honor. Would you like to have us come back in, or are you going to decide based on the supplemental briefing by submission?
I'll decide it by submission. I'll get you. When is your trial setting on this case?
It's August 31st, I believe.
We'll get you an answer within 3 weeks.
All right. Thank you.
Is there a specific time tomorrow that you would like them in by? Noon, 5, 8?
I know this is kind of short notice, so why don't you get it in by 5? Go ahead and e-file it in as well as email it to my court coordinator. And yeah, just do that if you could.
Be happy to do so, Your Honor. Thank you.
And no more than 2 pages per side. Okay, guys, thanks a lot. Interesting topic. You don't see usury that often, so I appreciate it. Good to see you guys.
Thank you, Your Honor.
Have a nice
Nice
day.
to meet you, counsel.
Nice to meet you.
All right, let's get to the next case. All right, who's here on the next case? Can you guys hear me okay?
Yes, sir. It's not me. Seating case, Bank of America, Daniel Nelson.
What time is your hearing set for?
It was set for 10 o'clock. I dialed in at 9:58.
Your Honor, this is Mark Travi. I think we are also set at 10 o'clock on a motion to sever, and I think there's also a motion to continue in DC 20-01712. It's Deborah Weaver versus KW New Vision.
Okay. I think Mr. Mims is for that too as well.
Yeah, he's got the continuance, Your Honor.
Yes. And FYI, Your Honor, we received an email from Mr. Miller. He's running a little behind schedule. He was in another hearing.
All right. Well, let's take care of Bank of America versus Nelson next. It's a scheduling conference.
Yes, sir.
when would you guys like to go to trial on this one?
Well, it appears that the discovery period on this matter would conclude at the end of December. So anytime after that is fine with us. It's a pretty cookie cutter debt claim case.
Who else is here on that?
I'm here, Your Honor. Jerome Brown is lead counsel, but I'm appearing for him because he's in court in San Antonio. I believe he had tried to contact opposing counsel's office, and they never got back with him. We were trying to agree to a pretrial order prior to this time. We just like to set it as far as possible to give us a little time to prepare.
What is your proposal?
What I didn't hear what opposing counsel said as far as his.
He said sometime early next year.
Okay, that would be fine with us, Your Honor.
When would y'all like to be set?
As soon as the court's availability as a first initial schedule, anytime after the close of discovery at the end of December. So that would put us in January, February. But I understand that given the ongoing COVID matters, that the court's availability may be a little further down the road than that. So however the court schedule works out is fine with us.
Do you anticipate this is going to be jury or non-jury?
At this point, we anticipate bench.
Okay, Ms. Brown.
We don't expect a jury trial, Your Honor.
So, we're constantly moving target right now. We had, been on a rotation for jury trials, and then we were, for a week there, we were doing regular jury trials, and then things got worse with COVID. And so now we're on back on a rotation. And so, I don't really know what to tell you. I do know on December 28th, I'm calling down a lot of non-jury cases, so we'll have a bunch of short trials just back to back. There's a lot of them. So that may, I don't know, how long do you think this case would take to try?
Oh, usually cases of this nature, 20 minutes, 30 minutes at most.
I just don't know if we're back on regular jury trials, this case would be delayed quite some time. If we're not back on regular jury trials, then I'm going to be trying as many non-jury cases as I can.
Okay.
So one option would be to set you on December 28th, because at least we know that week's going to be non-jury, or just we set you whenever and just take our chances.
I'm more than happy with the 28th for December. I was just looking and making sure that there wasn't any issue allowing for who initially began pro se on the defendant's end, that they were accommodating or happy with waiting out till the end of discovery to allow them sufficient time. But we're more than happy to allow for the 28th of December. But again, I'll leave it in the hands of recently appearing defense counsel to sort of lead our path here as far as when they find it to be good on their end. We're happy to accommodate both the court and the other side. We're flexible.
Ms. Brown?
Your Honor, if we could set it after the first of the year, I think that would give us a little more time, if that's possible.
I'm flexible. There's really, there's just tremendous uncertainty at this point. So if you guys don't want to do December 28th, then just tell me a date and I'll go ahead and set you then. I don't know that I can give you any certainty one way or the other.
Is there any availability in January?
No, not really, but we can set you whenever you want. We'll see what happens.
Okay.
Why don't we use a nice marker here as a holiday? February 14th. How does that sound?
Is this a case have romance in the air? Is that the is that
No. I'm looking at it's a Monday, and so I just
So we set trials on Tuesday, so we'll just set it on February 15th then.
February 15 works fine on our end.
And
That would be
so
fine, Your Honor. That would be
Rhonda,
great.
go ahead and set this on February 15th, and then just get us a schedule in order that corresponds with that. Okay.
Thank
Okay.
you, Your Honor.
Thank you.
Thank you guys. You guys be safe. Okay.
You too.
Appreciate it.
All right. right, Mr. Tarabi and Mr. Mims.
Yes, Your
Yes,
Honor.
Your Honor.
Your Honor, we're set. I had set our motion to sever, and then there was a motion to continue filed by plaintiff's counsel. The motion to sever is based on we've got the plaintiff's case that was originally filed against KW New Vision involving a dispute as to the ownership title to the property made the basis of the suit. Since that suit was filed, Your Honor, you may recall we had agreed on the appointment of a receiver to take possession of, list, and sell the property, which has been completed. So the property's been sold. The excess proceeds from the sale of the property after payoff of closing costs and the construction loan, the remainder was deposited into the registry of the court, and it's sitting there right now. So in essence, Your Honor, and I guess, and just to add to that, there was also a third-party petition and counterclaims, et cetera, filed by KW New Vision, which are in essence sort of the recoupment side of this case. So we were set for trial on tomorrow's docket, and from what I've been told from Rhonda, that I guess we're not going to get reached. I'm not really sure what the status is for
So is this a jury or non-jury?
non-jury, Your Honor.
So everything has changed. Let me just say this. Just a little bit of history. So, Dallas County has, since COVID, has created a basically jury plan that corresponds with the jury threat levels, the COVID threat levels, sorry, not jury threat levels, COVID threat levels that have been established by the Dallas County Health Department. So if it's red, there's no jury trials. If it's orange, then we have a rotation where juries are picked in the central jury room. If we drop to yellow, then we would do jury trials every week. And so we had been red for quite some time. We went to orange, and so we started doing a rotation. We dropped to yellow, and then we started doing regular jury trials, which is what I thought we were going to be doing this week. On Friday, Dallas County, because of this recent surge of the Delta variant and so many people not getting vaccinated, has gone back up to orange. And so our local administrative district judge has canceled all of our jury trials for this week. And so we have availability to try this case tomorrow. I didn't think we were going to, because I thought we were going to be in jury trials as of Friday. So we do have the ability to try this case tomorrow. And in fact, it would probably be a very good day to do it if we can. So just to give you a feel for kind of where we are.
Well, Your Honor, thank you for that, because I mean, basically I filed the motion to sever with the idea that we could at least try a part of the case as we were set. And essentially, the part that I think is right to be tried is really just a dispute between plaintiff and KW as to who's entitled to the proceeds in the registry of the court. That's a pretty discrete issue. The remainder of the claims, which are what I would characterize as sort of the recoupment side of this case, really are against the third parties that we added to the suit, and namely the seller to KW, who is alleged to have obtained title through a forged deed. And again, I think the other issue that's important for the court to note in terms of, I guess, whether or not the severance is proper, as the dispute between plaintiff and KW, there really isn't a dispute between plaintiff and KW as to the validity or the forgery of that deed. I think that's not the same, although Mr. Miller is tied up in another hearing. He told us to go ahead and just let him know how it goes, but I can assure you that his client is not willing to concede to that issue of forgery. So that's why I think that severance is appropriate, and why these cases could be tried separately and really need to be tried separately, because those two issues don't overlap. But again, the only issue, and I think it's a fairly quick trial, Your Honor, as to the right to the excess proceeds. as for my part of the case, I mean, I think I can present my entire case in 2 hours.
Response?
Yes, Your Honor. And to be clear, I know we're kind of talking about two different things right now, but I'll just address the severance first. The severance would require my client to litigate the same fact pattern twice. That's not convenient. That is prejudicial, and it's not just. Mr. Tarab, and in addition to that, the no dispute regarding forgery, that's the first time I've heard that. We discussed this issue 2, if not 3 weeks ago, and the request was for a stipulation to that point. And if we would have got that then, perhaps we would have been ready to go tomorrow. But learning today that there's no dispute.
Well, I thought he said there is a dispute as to forgery. No?
No, not with plaintiff. He said he believes that Mr. Miller's client is not going to concede the forgery. And that again brings up a whole issue of, well, are we going to have to come back then and testify regarding this fact pattern? That's not convenient. In addition, he's got my client in a civil conspiracy with Mr. Cyrus, as well as Ms. Fortner. And so, of course, then we've got to come back and defend a conspiracy claim. So, you know, had we cleaned up these issues that are, you know, kind of out there, I mean, there's no dispute about the forgery. Well, we've been preparing to prove forgery. And that's one of the bases for our continuance, because our expert is not available tomorrow. So having us work, you know, certainly in the last 2 to 3 weeks, you know, on a case that you're now not going to test, that's just not fair. It's just not fair under any circumstances. And it's unfortunate because, particularly with what the court has discussed today, there would have been a time, there was a window of time where we could have been set to go tomorrow on this narrow issue that Mr. Tarabi's talking about, and you know, may have happened. In addition to that, Your Honor, you know, again, I know we're talking about 2 issues. There's outstanding discovery that we've requested that is more than 60 days past due from the extension date that we provided Mr. Tarabi. So we've not had the opportunity to receive proper discovery. And of course, that's the subject of a motion to compel that is pending now, you know, depending on the outcome of our motion for continuance. So, you know, one, litigating two.
Let me ask this. If we don't sever this, when can this case be ready for trial?
Your Honor, there are, in addition to the discovery that's due plaintiff, counter plaintiff and defendant here has filed discovery and requested some documents that really will get to the meat of the issue one way or the other, whether it's narrowed or not. That involves some text messages. Those discovery responses were due today. We did respond, but we are withholding the production of documents until they respond to our previous discovery. In addition to that, the text message request that was made in there, we haven't received those text messages, and they are important. So I said that to say that puts us out at least 30 days. I do have some dates, you know, that the expert is not available. I went ahead and asked her for August and September dates that she wouldn't be available. But Your Honor, if they're going to stipulate to the forgery, then that would dispense with this requirement. And then, you know, that opens up a much different window of time. So, you know, you're kind of showing up and say, well, we don't, I mean, you know, that's not sufficient to have the issue of forgery go away. We either need a stipulation or we're going to try it and get, you know, a ruling from this court. It's one or the other.
Response, Your Honor?
Yeah.
Your Honor, we're set for trial tomorrow. And I mean, there's no motion to compel that's set before the court. Any discovery, you know, dispute should have been settled long time, at least 30 days before the trial.
When were these new claims added?
June.
No.
Yeah, June. The new claims were added after the last hearing, Your Honor.
What, our third-party petition was not filed in June.
The unjust enrichment claim was added in June.
You know, again, Your Honor, these claims are what I'm trying, this is exactly the basis for the motion to sever. They have nothing to do with what's right to be tried tomorrow, which is who's entitled to the money in the registry of the court. The issues that Mr. Mims is addressing, again, really relate to.
But you added these, right? You added these claims, correct?
Correct, but again, they really relate to the recoupment side of the case, not to the issue that's right to be tried, which is who's entitled to the money in the registry of the court. Those are severable issues, and that was the basis for the motion to sever. And there's really no, you know, again, we've been in that case has been on file since plaintiff filed the suit in January of 2020. So, you know, we've been ready to go. And again, with regard to this issue of the stipulation, Mr. Mims represented, we haven't discussed this. That's absolutely untrue. We've discussed this, and and Mr. Mims sent over then a proposed stipulation that included additional stipulations that are far and above just me stipulating to the issue of forgery. So you know, that's the reason that there wasn't a response to the proposed stipulation that was sent over by counsel. However, I have never at any time made any representation other than between the two of us, we are prepared to stipulate as to the issue of forgery, and his expert on handwriting is not necessary to try the issue of who's entitled to the money that's in the registry.
Your Honor, may I be heard, please?
Sure.
That is incorrect at best, and it's not accurate representation before this court at worst. I did send a specific stipulation. It requested two things. It requested that he acknowledge that my client did not sign the deed and did not authorize the signature. Those are the two requirements that would be necessary for us to dispense with forgery. Did she sign it? Did she authorize it? That's it. I can file that for the court. So these new claims, that's just not accurate, number one. The only new claim, I mean, the respect to him stipulating, it's just flat out not accurate. The only new claim is this unjust enrichment claim, which we do need some time to flush out. And here's why, Your Honor. And I'm glad we brought this up, because the way that this claim is currently pled, it either requires him to prove that my client had some type of malfeasance to satisfy the unjust enrichment claim that he pled. As the court may be aware, and I've done the research or begun to do the research, there is a big distinction with respect to unjust enrichment, with respect to malfeasance, which typically relates to two parties who have some relationship. And then there's this other claim that he's not made that's related to quantum merit. So, you know, we want to make sure that we're proceeding under the right fact pattern, and that he's pursuing something that he's pled, and we're not sure of that right now. Again, this unjust enrichment claim was raised in July for the first time after we told him he needed to make a quantum merit claim. So, you know, defendants had 3 continuances. This is plaintiff's first. We believe it's for good cause. Unfortunately, yeah, it probably could have been aborted 2 weeks ago, but to sit on the sideline after we send the stipulation and say nothing, don't say anything, particularly not what was said here today, and then show up and say, well, we're ready to go. I mean, we don't have any issue with it. That's not candor before this court, and it's time for someone to say it. It's just not candor before this court, Your Honor.
Yeah, I'm object to those mischaracterizations. We're set for trial tomorrow. And this discussion with regard to the stipulations, clearly Mr. Mims is acknowledging we had that discussion. His proposed stipulations included more than what I was willing to agree to, and that's that. I mean, again, I really object to the mischaracterizations, and frankly, Your Honor, the only issue that's ripe to be tried, and really there's nothing for us to be disputing, is the equitable claim for improvements. The rest of the
There is
issues
no
are separate.
equitable claim for improvements. There's no such thing as an equitable claim for improvements. Let's get that out the way, Your Honor. So
Well, try that,
we'll certainly need to flush that issue out. We did tee it up, and we withdrew at the hearing at that time for some procedural reasons, but that certainly needs to be the subject of a pretrial hearing or conference. So that's number one. And him saying it's severable, yeah, it may be severable, but that's not the end of the discussion. Does it inconvenience my client? Absolutely. Having my client litigate the same facts twice is just a flat out inconvenience. I don't see how.
Well, let's just kind of figure this out. So you need how much time to get ready for this? I mean, this is the deal. I can try this tomorrow and we have a certain date and we can potentially finish this case tomorrow. I don't know what's going to happen in the future, especially this is a non-jury. It becomes very uncertain what happens. And so I know that it's not ideal to go to trial this week, but there is some certainty. I
can appreciate that, Your Honor. And unfortunately, if like I said, I'm going to file that stipulation. I want the court to hopefully recall what was communicated during the day. But the point is that we won't be ready to go tomorrow. And the least amount of time that would probably be 30 days. I know that puts us in a window that the court doesn't have much, foresight in, and that's unfortunate. We sat by and watched 3 motion hearings. It's not like we're just sitting here, wanting to continue for no reason. I mean, there are valid reasons that we request this continuance. So we would ask that the court grant our motion for continuance. And when you say you can try this case tomorrow, are you meaning the severed case or the whole case? Because I don't know if certainly with respect to all the claims, I don't believe.
I'm just saying I have time. That's my only point. I have time tomorrow. I don't know when I'll have time in the future. If you wanted to try the severed case, I could try that. I could try the whole case if you guys agree to that. I just have time. I don't know when I'll have time again. That's.
I understand, but unfortunately, Your Honor, we're not prepared to go tomorrow, so we'll have to deal with the uncertainty.
Mr. Traube, I guess your option is if you want to non-suit these third-party claims and just go to trial tomorrow on the original claims, we could do that. Otherwise, I do think it probably needs to be continued.
Well, Your Honor, I think that there's still a basis for the severance, whether we try it at a different date or not, just because it would be difficult, if not impossible, to try these issues. Again, we are stipulating to the fact of forgery as between plaintiff and KW. So that's a separate trial. And the trial against Mitchell Cyrus or Cyrus Mitchell, I keep forgetting which way that goes, as well as the notary, Deborah Fortner, that issue is a completely different trial because they are obviously not going to concede to anything as regard to the forgery of that deed. So, again, I think even if we keep them together, we'd still have to, at the point of trial, deal with the issue of, you've got 2 separate things going on. And the only issue, again, between plaintiff and KW that I believe is ripe to be tried right now is who's entitled to the money in the register. Money's sitting there, Judge. I mean, it's just a matter of, okay, she's got a deed that was forged.
Mr. Traube, I'm giving you 2 options here. Either you non-suit the claims and you can refile them in a separate lawsuit and you can, of course, get it transferred here. Or we need to. I agree with Mr. Mims that this would be an inconvenience, and this is a bench trial, so trying it all together is not going to prejudice me or anything. So either we go to trial tomorrow and just the original claim and non-suit the other ones, or we just continue the case. I'm not going to sever it.
Well, I don't know that I can non-suit and refile. There may be some limitations issues. I'd have to. That would not be something I could agree to without looking at it.
And Your Honor, with the refile, would that include the civil conspiracy claim against my client? I mean, that's what I don't understand. He said my client is colluded with these people. So.
It sounds like he's not going to agree to it anyway. So we'll go ahead and reset this 30 days and we'll just take our chances. So
And Your Honor, lastly, is that stipulation, because I think he said he stipulated it. I want to be clear here. Did he stipulate to the forgery? Or,
There's no stipulation unless you both agree. So people can say, I stipulate to this, I stipulate to that. Unless the other side agrees, there's no stipulation. So you guys work out a stipulation. All right, guys, we're going to reset this to August 31st and see if you can get it ready.
Thank you, Your Honor.
Thank you, guys. And severance is denied.
Thank you, Judge.
All right, guys, I need to take a quick break. I'll be right back. Okay, guys, come on back. Everyone turn on their cameras. Those of you who have the lunch today at 11:45, go ahead and leave whenever you need to go to that. And we'll go ahead and get started with this hearing. All right, can you guys hear me okay? Can y'all hear me okay?
Yes, Judge.
All right, are you guys here on the motion to compel? Are you guys here on the motion to compel? Mr. Carlton, what are you here for? What happened to them? Mr. Carlton, what are you here for? Mr. Carlton, can you guys hear me?
Yes.
So I don't know what these folks are here for. Mr. Carlton, what are you here for? You need to unmute Mr. Carlton.
Can you hear me, Judge?
Yeah, what are you here for?
Yes, Judge. I'm here on the Weaver case. I think it was at I don't know if you've already heard the motions. There were a motion to sever filed by Counselor Tarabi, and then I believe Counselor Mims and I.
Yeah, so I denied the motion to sever and I granted the motion for continuance and I reset it to August 31st.
August 31st. I'll put that on my calendar right now. Thank you, Judge. I appreciate your time.
All right, are you here on, are you also connecting on another device at this point?
No, I don't believe so, Your Honor.
William Ashcraft, is he with you?
No, Your Honor.
Okay. All right, good to see you, Mr. Carlton. We'll see you soon, okay?
Have a blessed day, Your Honor. Thank you.
You too. I don't know what Mr. Ashcraft is here for, so